Okay, if everyone's ready, we'll open court. Gene?
The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Gene. Good afternoon and welcome to the North Carolina Court of Appeals. My name is John Tyson. Your panel today will include Judge Lucy Inman and Judge Toby Hampson. We have one case this afternoon to be argued. It's the case of Hovey versus Sand Dollar Shores Homeowners. And if there's no other preliminary matters to come before the court, we will hear from the appellant.
Mr. Shelton, we can't hear you.
I apologize, Your Honor. Thank you. May it please the court. My name is Troy Shelton, and I represent Sand Dollar Shores, the HOA in this appeal, along with my co-counsel, Justice Bob Edmonds, who's to my right. I'd like to reserve 5 minutes of my time for rebuttal. This case presents one primary issue. Did the developer of Sand Dollar Shores intend to give away the neighborhood's beach access to the public in exchange for nothing? The plaintiffs say that the answer is yes, but the only evidence that they have is a recorded plat. But that plat can't bear the weight that the Hoveys put on it. The law in this state is that a public dedication must be proven with clear and unmistakable evidence of the dedicator's intent. At most, however, the plat is ambiguous as to the beach access, but an ambiguous public dedication is no dedication at all. Because the Hoveys had no other evidence to rely upon in the trial court erred in granting summary judgment in their favor and should instead have granted summary judgment in favor of the HOA. And for that reason,
Mr. Sheldon, that actually kind of gets to sort of my first question more procedurally. And I guess you've sort of answered it. And that is this truly a summary judgment case, or is it your position that there could still be some genuine issues of material fact that would need to be resolved on remand?
Your Honor, I think that the one thing that I might agree with the Hoveys is that there is no issue of fact in this case. They have narrowed their theory only to an express dedication, so it's up to the court to look at the plat. And we think that the plat is unambiguously clear, especially with respect to the standard of proving clear and unmistakable evidence, because they can't overcome what's essentially a presumption created by that standard. We believe that they lose and summary judgment is appropriate for the HOA. So there's no need to remand for a trial, for instance, even if the court were inclined to reverse.
So you're asking this court to reverse the summary judgment in favor of the Hoveys and remand for entry of summary judgment in favor of your clients?
That's exactly right, Your Honor.
Okay, thank you.
Turning first to the law, a public dedication in this state requires clear and unmistakable proof of the dedicator's intent. Below, the Hoveys managed to convince the trial court that intent, in their words, is not legally relevant, but that was an incorrect statement of the law. In fact, the law in this state for over a century has been that intent must be proven even for an express dedication. It must be proven with clear and unmistakable evidence, and evidence that is unequivocal and unambiguous. The Hoveys have also suggested that the recording of the plat is somehow a substitute for proving intent. That's not exactly right either. Instead, when a party is relying on a written instrument like a plat, it's the written instrument that must show clear and unmistakable intent to make a public dedication. Importantly, when a party is relying on a written instrument like a plat to create a public dedication, any ambiguity is resolved against a public dedication. That's what this court held in Wright versus Town of Matthews in 2006. In that case, there was a chain of deeds that had a reservation for a 60-foot right-of-way. And the reservation said that it was, quote, for street purposes. And the question was whether the phrase for street purposes was language that created an express dedication. This court held that it did not, and it explained that the reason was because the deed failed to specify either way whether such a right-of-way was for purposes of a public street or a private street. And therefore, this court held that this could not be clear and unmistakable evidence of an intent to dedicate, and therefore it reversed the trial court. This case is just like Wright, because the beach access has not been specified for being for public use. I think it's helpful to walk through the plat itself and ask where, if anywhere, there's clear and unmistakable intent of the developer to dedicate the beach access to the public. The plat is.
Mr. Shelton, before we go there, I want to, even were we to agree with you under the common law, don't we have statutes and ordinances in Currituck County that would override the common law here?
No, Your Honor. So this court has repeatedly said that public dedication in this state is a matter of common law, and none of the statutes or ordinances that have been cited by the Hoveys even make an attempt to overturn the common law. The closest that they have is a DOT statute, and really all it says is that if you record a plat and there are streets and roads on that plat, and any of those streets and roads say that they are designated for public use, then we're going to consider that a public dedication. But that's merely a codification of the common law. It's not an overturning of the common law.
So when the county put their certificate on the plat that's recorded, that in and of itself has no meaning or no evidence of acceptance. Is that correct?
I think that the plat is the evidence. Well, it's the only evidence of acceptance that the Hoveys have, of course. And so it does say certificate of approval for recording a plat and acceptance of dedication. So, but you know, this form language that the county used just says we're accepting whatever it is that you, the developer, are dedicating.
So isn't that the very same language this court upheld in the Ocean Hill joint venture case?
Well, I don't think that this case really turns on a question of acceptance, because before you get to acceptance, you have to first determine whether there's been clear and unmistakable evidence of an offer. And in this case, there is no offer. There's an offer of something. The question is whether the offer includes the beach access. So it's really a question of scope. The question is, what is within the scope of the offer and what is the scope of the acceptance? And I think here, the acceptance is certainly no broader than what the offer is, nor could it be. You know, this court has repeatedly analogized the law of public dedication to the common law of offer and acceptance. So if the acceptance were somehow broader than the offer, then the acceptance would be invalid.
So Mr. Shelton, just to clarify, is there any dispute in this case that the developer and your client dedicated the roads in this subdivision to the public, and that the county accepted that public dedication with respect to the roads?
Your Honor, I think there is no dispute. We willingly concede that the roads have been dedicated to the public. If you have record page 12 in front of you, after the developer says, "I'm dedicating all roads, alleys, walks, parks, and other sites to public or private use as noted," you then encounter the very first note on the plat. And it says, "Note," in all capital letters, "the streets and roads in this subdivision are dedicated to public use." We think that that's clear and unambiguous. That's the type of evidence that the Hoveys need to win this case, but there isn't any other evidence of anything else being dedicated. So at a minimum, we agree that the roads and streets have been dedicated for public use, and they've been properly offered and accepted. The question is whether the beach access has also been offered and accepted.
Mr. Shelton, what's your position on the dedication of the 20-foot emergency access easement? What was that dedicated? It seems to me in some ways that's maybe more analogous to the beach access easement than the road, which I think everyone acknowledges was dedicated expressly. But so talk to me a little bit about that comparison, the emergency access easement and the beach access easement.
Well, so Your Honor, the emergency access easement, I believe, was required actually by the plating ordinance to be included. And so it's been marked here, but it's not, it's a very, to the extent it counts as a public dedication, it's incredibly narrow. It wouldn't allow for, even the homeowners to be parking there. It would only allow an emergency vehicle to be parked there. I think that it's at least a close case whether that's been dedicated to the public, but certainly not the type of public dedication that you normally have in mind, where it's free and open for anyone to use. The Hoveys aren't, they're not entitled to bring a fire engine, for example, and park it there for their own private use at the end of the road.
So the only dispute here is this pedestrian beach access. That's all that's in dispute here.
That's right, Your Honor. And so when you're looking at page 13, you see Seabreeze Drive, for example, and I think that we all know that that's been dedicated to the public because that's a street or a road. And on page 12, the developer says that he's dedicating streets and roads to the public. So the only question is whether the pedestrian beach access, which here is called an 8-foot pedestrian beach access easement, has also been dedicated to the public. But there's no notation beside of it. It doesn't say one way or another. And in that sense, it's exactly like Wright, where the deed said that it was making a reservation for street purposes. And the court said, well, street purposes could be public street purposes or it could be private street purposes, but it's not noted in the deed. And here's the exact same.
And maybe that goes more to my question, is that, if the argument is looking at the plat and we look for offer and acceptance in this case based on the plat, where is the dedication on the plat, or the offer of dedication on the plat of the 20-foot access easement? It doesn't necessarily, if an easement in and of itself does not fall within the sort of the notations on the plat as expressly dedicated. I'm just trying to distinguish the two situations there, and I'm hoping maybe you can help me and point me to where that easement was so expressly dedicated.
Well, Your Honor, I think that the court would be entitled to simply consider the context. Who is it that drives emergency vehicles? It's the government. It's the government that would be entitled to use that easement. Wouldn't be, of course, there's no reason for thinking that would be the public in general. It's hard to say whether that is or isn't a public dedication. There are simply not any cases they're very much like that, where there's something where when you look at the context, some governmental entities may or may not be able to use it. Most of the cases from this court are about streets and roads, whether they've been dedicated, or paper roads, as they're sometimes called, where they're shown on a plat, but they're not actually ever built. Walkways, those are the types of easements that are typically addressed by our court. So unfortunately, I can't offer much more guidance besides the fact that, I think a party could look at that and that could go either way. And I think because the standard is clear and unmistakable, there's a good argument that it might not quite meet clear and unmistakable, but that would be a close case, if the Hoveys had that kind of context. But of course, we know that a beach access can be public or private, but an emergency vehicle easement, I think almost everyone would probably agree that that's there for governmental use. So in that sense,
Mr. Shelton, you're saying then that the fact that a government entity, a public entity, has a right of use or an easement does not mean that the general public necessarily has a right to use it. Is that basically your argument?
I think that sounds right, Your Honor. I think that would be like a utility easement. I think a utility easement is probably a close analogy to this emergency vehicle access easement, where there's this very limited use for a very particular type of user, but not for the general public. And that's why public dedication cases don't tend to talk about those so much, because it's not really a public user issue.
Mr. Shelton, Judge Tyson mentioned, I think it's the Ocean Ridge case, or the Ocean Hill case, excuse me, the Ocean Hill case. And you touched on that in your reply brief, I think, but could you just distinguish that? Any any further? Because you started to mention that it was a different issue, and I just want to make sure I'm understanding the distinctions.
Yes, Your Honor. So Ocean Hill has zero analysis of public dedication law. All the parties agreed in Ocean Hill that whatever had been the easement or the road at issue there had been dedicated to the public. So it would be the most sub silentio of sub silentio readings to hop from there to decide that there's been a public dedication in our case, because the entirety of Ocean Hill is about a statutory procedure for closing public roads. You only get there once you decide that there's already been a public dedication, but we're here to decide whether there has been a public dedication in the first place. So given that that's the question, Ocean Hill really can't offer any answers to that.
So in Ocean Hill, there was a concession, I think, on appeal of public dedication. And the issue was, what can you do after you've done that?
Yes.
Can you take it back? Can you take it back?
You take it back. And we're not here trying to say we've taken it back. We're here to say that the developer never gave it away in the first place.
And what impact will our decision in this case, if any, have on other subdivision beach access easements in the town of Duck?
Well, Your Honor, you can tell, I think it's probably obvious from the page 12 of the record, the front of this plat, that this is a form plat. In fact, if you look at the ordinances themselves, they say that we're requiring you, when you file your plat, to use one of our forms. You can find that on page is in the ordinance. I apologize.
Okay. Well, while you're looking,
I'm sorry.
that's
go
okay.
ahead.
While you're looking for that, what I was getting to is, I don't know if you're a fan of Joni Mitchell or ever heard the song "Big Yellow Taxi."
I'm sorry, I'm not familiar with that.
Well, it's a song about paving paradise and putting up a parking lot.
Yes, Your Honor. I'm sorry, I wasn't.
And putting all the trees in a tree museum and charging all the people $1.50 just to see them. As I understand the Hovey's arguments, it seems like a populist argument that, wait, I'm a homeowner in the town of Duck, and I have to leave town to get to the beach. And if you could just square that with the common law and explain why that is what the common law says in this case, if that's your position.
Well, Your Honor, there is no law that that would say that any private beach access that you want to use, you're entitled to use if that's the easiest and most convenient way for you to get to the beach. That's not the law in this state. I'm not sure that that's the law in any state. I think it's also helpful to think about not just the effect on the Hoveys, but to think about the effect on the homeowners themselves. I think there are at least 3 distinct harms that I can think of. If the court were to essentially flip the presumption, there's been 100 years of a presumption against public dedications. And so if that presumption were to be flipped, in this case, first, these homeowners all bought with a very reasonable expectation that they were buying a private beach access. And of course, they naturally paid a premium for that. But if their access is suddenly converted to a public beach access and everyone else still has their private beach accesses, if another home goes up for sale in Duck and these homeowners' home also goes up for sale, they're going to have to sell at a discount because everyone's going to pay a premium for a private beach access. The second issue is to think about is the safety issue to these homeowners. If this becomes a public beach access, then there are going to be people flocking to this access. Now, I understand the Hoveys are going to say, well, there's an ordinance in effect saying that they can't park here. Well, there's also laws in effect saying you can't speed. I think we all know that just because there's an ordinance in effect saying you can't park at the end of this cul-de-sac doesn't mean that people aren't going to park there. And even if they don't, people could be Ubering there. And it could be a revolving door. There's no trash cans there for people to throw their trash in. This access will get treated like a public access, but not actually be taken care of. And we know that because the town has said, whatever the result is of this case, we're not maintaining this beach access. We're not going to do it. And so because they've made that point, I think it's critical to understand that this beach access, like every other beach access, is just one hurricane away from not being a beach access at all. So if this court were to affirm the trial court's judgment, next hurricane that comes through, this beach access could be blown away. The steps could be blown away. They could be washed away. The dune falls over, and someone's gonna have to come through and clear it out. The HOA would be trespassing to be coming in and doing that. They would, at a minimum, have to get the government's permission to do it. But even then, why should they have to do it if it's a public beach access? So those are the harms that I think that are not quite taken into account by the Hovey's position. There's also the separate problem that there is no special beach access rule for public dedications. There is one law of public dedication. So if this court were to, for some reason, flip the presumption on its head in this case, it's not going to just affect Seabreeze Drive. It's going to affect the thousands of subdivisions all across this state. All those subdivisions that have been platted, where the surveyors relied on the presumption that if they don't designate something as a public dedication, then it's not a public dedication. And so thankfully.
So let me ask you this then. You talked about the length of time. The presumption, would you agree the reason for the presumption is if the public does receive the benefit, the private owner has been deprived of a property right without compensation. So is the presumption rooted in the Fifth Amendment and the takings clause that you're not to take private property for public use without just compensation?
Yes, I agree with that, Your Honor.
So in the case here, if we were to upheld a trial court, the private property owner would have been deprived of, would give over their rights to public use without compensation.
That's right. There would be no compensation in this case because a public dedication has no consideration.
And are you also saying that there would be no public responsibility to maintain or to keep it clean so that an additional burden would fall on the homeowners to carry an additional public burden of maintenance as well?
I think that's right, Your Honor, given the town's statement that they don't plan on taking care of it. I mean, the town doesn't have to maintain it. They don't, they can accept a public dedication and offer a public dedication without agreeing to maintain it. Now, I'm not sure they can escape their tort liability if someone were to, slip and fall or get a horrible splinter and get an infection when something, could have obviously been prevented through maintenance. That's an issue for the town, I suppose, if the judgment's affirmed. But yes, Your Honor, I agree that, the homeowners are, we essentially have a problem of the tragedy of the commons, and the homeowners here are going to have to carry the public cost without getting any compensation.
And just to be clear, nobody's taking the positions that the Hoveys aren't allowed to walk on every single inch of beach at the ocean and dock, right?
That's exactly right, Your Honor. They just can't use our beach access to get to the sand.
Okay.
Your Honor, this is a case.
Yes, are there public beach accesses that are provided?
In the town of Duck, I'm not familiar with public beach accesses. And in that town, of course, you can drive to Corolla. I believe up north, there'd be beach accesses. I'm pretty sure there are beach accesses to the south. The town of Duck, however, I think their position's been that beach accesses here are private. But even though they're private, the public's not essentially cut off. There's tons of rental homes in Duck, and that's essentially how the public accesses the beach. They rent one of these homes, and they have access to the beach. And there's other ways that people can access the beach when they live on the sound side, like the Hoveys. For example, many of these subdivisions, when the developer subdivided them, he owned the whole thing. He owned the road all the way from the sound to the ocean. And so everyone on the sound side and on the ocean side all gets to access the beach on each side. There's also the situations where a different HOA could enter into an agreement with the Hovey's HOA. There's nothing stopping them from entering into an agreement with this HOA. our HOA, us, and having a private agreement where their members get to use our beach access. But the Hoveys, aren't interested in paying for the private beach access. They want to have the beach access without paying anything for it, because that's how the law of public dedication works. And so thankfully, this is a case where we really all know what the developer actually intended. He intended that this beach access would be reserved for the private use of the neighborhood that he was developing and not for the general public. That's what the plat shows. That's what the contemporaneous declarations filed 2 days after the plat show. And that's how everyone has treated this beach access for the past 40 years. The trial court had no basis for converting this private beach access into a public beach access. There is no law that supported that result. And therefore, the trial court erred in granting summary judgment in favor of the Hoveys, and summary judgment instead should be entered in favor of the HOA. Thank you, Your Honor. I'll reserve the balance of my time for rebuttal. Thank you.
Thank you, Mr. Sheldon. At this time, we will hear from the appellee, Mr. Wills.
Wills, I represent Mr. and Mrs. Hovey in this appeal. And I have listened closely to what's been said, both the questions and the arguments advanced by Mr. Shelton, and I'll try to get directly to some of the points made, of course, answer your questions. I've been afforded the opportunity to share documents as I've appeared before the Court of Appeals before. You have that overhead projector, and I'm going to attempt to do that in this online call and direct your attention, I think, to some of the documents that I think you should look at, and my understanding is they will appear on the screen for you to review. Before doing that, I do want to say that the Hovey's contention is very clearly that when the developer of this subdivision filed a plat that specifically says that we dedicate to the roads, the walks, and other things as shown on the plat, and the town expressly accepted those by the language that I'm going to show you right now in the plat, then the effect of that was to make a complete offer and acceptance. And I believe the case law that is cited in my brief supports that assertion in North Carolina. I will say that this argument that, as Judge Tyson noted, that in order to have the offer and acceptance by use of this standardized language become applicable, then the plat itself must specifically designate on the word public or private is not borne out by case law. And in fact, the argument that Mr. Tyson is making here is that this court should somehow create an exception to the general dedication of public right-of-ways, roads, alleys, and easements only to those circumstances where they specifically put on the plat that this was private or this was public. In the 4 prime cases cited in the appellee's brief, that was not the case in any of them. In every single one of them, you have dedication language virtually identical to what we have here. You have acceptance language virtually identical to what we have here. And then you have a map that either shows the road or it shows the easement, in one case, a stormwater easement. And there's no indication from any of those cases that the plat itself put the word public or private. It was the dedication language and the acceptance language that was binding in all of those cases.
Mr. Wills, Mr. Shelton has argued that the Ocean Hill case is utterly distinguishable because in that case, the issue of dedication had been stipulated.
I acknowledge that case stemmed from a petition by a homeowners association to have the county declare the roads to be private. But it is true, and I do have those plats to show you, that both the language, the factual circumstance I just described is identical. That is the offer, the acceptance, and then the plat showing the roads, but not designating on them whether they were public or private. And were that to be the case in the Ocean Hill case, there were motions for directed verdict. The issue in Ocean Hill was primarily on whether or not the judge should have entered directed verdicts, and then it was the jury instruction on this precise issue that we're talking about as to who had the burden of proof. If the law was, as Mr. Shelton asserts that it is, then the result should have been different for this court. He's correct. It wasn't expressly addressed, but I submit to you, it was impliedly addressed on almost virtually identical facts, where even in the Ocean Hills case, if you read that, the Homeowners Association, they had maintained the streets. They had received a declaration or a conveyance from the developer to themselves for title to the streets after they had been platted and accepted. And so you couldn't have gotten to the place that you were in Ocean Hill if his legal arguments were correct. And on numerous occasions within, so I do acknowledge that procedurally the status of it was public trying to make it private. But I do believe there were opportunities by judicial, decisions throughout the course of that trial and the appeal to have made this argument and perhaps ruled as a matter of law if it is as clear as he asserts it to be.
Well, following your argument, as I understand it, that it's not the plat language that matters. In other words, it's not in this, hypothetically, if the plat in this case had no language dedicating anything to public use, it didn't say we dedicate all roads, except, would the easement be dedicated to the public by default?
No, ma'am, I don't believe it would. I believe that the argument that I'm making in my brief is that when you have an express offer of dedication and you have an express acceptance of dedication, and this is primarily stems from the Emanuelson v. Gibbs case, when those two circumstances coincide, then you do not go into much of the other common law analysis. You have offer, acceptance as shown on the plat. That is exactly, and again, the Emanuelson v. Gibbs case cited in my brief also addressed the issue of who maintains it afterwards. And Emanuelson v. Gibbs makes it perfectly clear that under North Carolina law, the public officials' acceptance of the dedication doesn't bring with it any obligation to maintain it. And therefore, the issue that Mr. Shelton raises with regard to maintenance has been specifically addressed by our courts and held that it is not an element or even a consideration in regards to whether or not the dedication is official and irrevocable by the developer or in this case by the presumed assignee of the developer's rights, the HOA. Only the statutory process enacted by the legislature, as was done in Ocean Hill, can revoke that.
Let me ask you this, does the ordinance require a dedication of beach access?
Not expressly, Your Honor. I can show you. I will, if I may, go ahead and share these documents. And Judge Tyson,
before you do that, let me ask you one other question. Is it possible for a plat to be recorded that contains both public dedications and easements that are private?
Yes, I believe you could do that under the county ordinance. If you are going to have reservations, the county ordinance expressly states that if you're going to have private roads, is what it says, you have to fully disclose that this will never be taken over by the state and will never be maintained. So,
Can you also
and
address the language in the plat that Mr. Sheldon referred to, that in bold, that expressly limited the public dedications to the streets and to the cul-de-sacs?
I would, and if I may, I'm going to go ahead and share this with you now. And
Is this the one that's on pages 12 and 13?
yes, Your Honor, it is. And I'm understanding that you all can see. So this is record page 12. Please let me know if you all are able to see my enlargements and things. Able to see this?
Thank you for enlarging it.
Yeah, we have
Okay.
we have a copy in front of us as well. So
All right. So the first thing that I would note, this is the language that we're talking about. The first thing I would note is this is the certificate of ownership and dedication. You will see this area here is where the developer signs. The developer is signing above a notary certification. I submit to you that this are the representations of the developer. And what the developer says, the owner of the land at this point, is that we are the owners of the property shown and described herein. As you know, this plat consists of two documents. What they're referencing, the developer is referencing now, is the attached plat. And they dedicate all roads, alleys, walks, parks, and other sites to private and public use as noted. And further says, we certify that the land as shown, so we're again referencing the attached survey, is within the platting jurisdiction. Now, the language that Mr. Shelton is referencing is not above the certification or the signature of the developer. Instead, it is.
Before you move on to that other portion, just looking at this part that's above the signature of the developer.
Yes, ma'am.
What's it mean to dedicate roads, alleys, walks, parks, and other sites to public or private use as noted? It seems to me, unless there's a note, how would you know whether it was public or private?
That I do agree kind of with the assertion that you're making, Your Honor. And that is that if I'm going to make something private, I need to designate it as being private. And there is a certain logical inconsistency in the defendant's position here that, oh, we all know the road is dedicated, but we didn't put public on the road. As Judge Hampson noted, we didn't put public or private on the utility access easements for the public vehicles. What I would say to you is you need to first recognize that the note that they're talking about is not above the signature of the developer. It is instead above the signature of the planning department. It's down here. This is the note. The streets and roads in this subdivision are dedicated to public use. However, the maintenance will be the sole responsibility of the adjacent owners until they are brought up to the standards of North Carolina. And then it's simply reciting a general statute. I submit to a proper reading of this language here is that the planning department is putting the public on notice of a statute that exists. Now, correspondingly, when you look at the acceptance language from the town, at that time it was a county, it says we are accepting the dedication of roads, easements, right-of-way, public parks, and other sites for public purposes as shown. So I submit to you, if as Mr. Shelton asserts, that this is the form that a developer uses when they are not creating a private area within the subdivision. And the notation that he asserts to be that of the developer is not a statement of the developer, but rather a statement of the planning department, simply reciting and citing to a statute.
So,
Now,
Mr. Wills,
no.
is it your argument then that this particularly for purposes of some of the statutory arguments you've raised, is it your contention that this beach access easement really falls within the definition of roads and streets that would be governed by statute?
Yes, Your Honor, expressly. And again, they are dedicating walks in the appellant's brief. They try to make a distinction between the fact that my client omitted the word easement, but did include the word walks. I say to you, when you use that language in conjunction with a plat that shows an 8-foot pedestrian easement, that it's a distinction without a difference. It's a walk. It's a way to go from one designated public area to another designated public area, which is the beach, via a publicly dedicated walk. And the notes that the developer certification is referencing should be the notes that they put on their plat. If they wanted to make any portion of this private, they had the ability to disclose it, and at that juncture, the county or the town could address or do that, or address the issue or do something with it. There's a couple of other points that I think are important for the court to know and understand, and that is when you look at this subdivision and you look at this map, there is no common area. There is nothing to be retained. Later, when you consider that the developer purportedly conveys any rights that they have 10 years after the plat is filed. So according to this record, in 1990, a homeowners association is formed, and the developer purportedly conveys that which he retained by contractual right. The developer retained no land. The easement here is between lot 2 and lot 3. He had nothing any different than any other lot owner had, which would have been an easement. And I do want to make another point that I think is important to this court's analysis. And that is, first off, please note that when we talk about a road, we're talking about a 60-foot right-of-way. And so each lot owner only owns title from the edge of their lot, from the edge of the 60-foot right-of-way. They do not own up to the edge of the road. And the reason I say that is significant is because as you look at the covenants, and as counsel stipulates, we submit, we don't deny that we made a public dedication of the road. The covenants, which they assert to be evidence of the intent of the developer, show that public use or parking on the subdivision road is prohibited. They purport in the covenants filed 2 days later to have the ability, let's see if I can get you to this, to control parking in the area of the right-of-way. So parking of vehicles by the public on the subdivision road, CB Drive, is prohibited, and vehicles violating this restriction will be towed away at their owner's expense.
But is that really making an effort to regulate the public, or in this context, is it not simply done in the context of the homeowners association, their ability to regulate the property owners to ensure their guests, et cetera, aren't publicly parking on the street?
Well, again, the analogy or the argument that was made by the appellants was that this is evidence of their intent. They are expressly saying that no. Let me go back further. They say that. Well, first off, they do say with regard to the easement rights, that nobody can use it but them, and they'll be prosecuted. And then they say that there will be no parking except lot owners. And we simultaneously stipulate that the county has, or I'm sorry, in this case, the town has the dedicated full 60-foot right-of-way. The town, if it elected to do so, could put parking along that road because it's been dedicated. Right now, the town makes it a criminal offense to park along the side of the road. These covenants purport to give the lot owner the right to park upon the road. And I guess that's my point. Once they dedicate land to the public, then the homeowner or the developer doesn't have the ability to control the land that has been dedicated, yet they are filing covenants purporting to do so. And that is very much the situation that we have.
But the dispute here is not about the road, right? The dispute's about the pedestrian easement.
Well, I guess what I would say is that it's
just focus on the pedestrian easement.
Well,
that would
again,
be more persuasive to me.
Well, the assertion and the central argument, you know, counsel is correct when he says that my central argument is that when you dedicated the walks and the roads, you have an express dedication using the term walks as shown in the plat, and you have an acceptance, then just as they dedicated the road, even though they didn't put the word private or public road on there, they also dedicated the easement, including the 8-foot easement. That is my central argument.
Mr. Wills, you said that the dedication of beach access is not required by the ordinance. So is your position that the developer gave this easement to the public as a gift?
No, Your Honor. It is my contention that the developer didn't give the easement as a gift or the road as a gift any more than they gave the road as a gift.
The road was required by ordinance. The dedication of the road to provide public access and also the emergency access, those dedications are required by the ordinance, are they not?
No, the ordinance allows you, if you want, to create a private road. You have the right to create a private road. It's not mandatory that you make it public. But if you are going to make it private, you have to disclose in your plat and in your covenant language, or a combination of it, that the county will never maintain it. They had the ability to make it private. They elected not to do so.
It had to be brought up to standards to be accepted for public use. Is that not correct? Isn't that the point of the note, putting the homeowners on notice that until the road is improved, it will be in fact a private road, correct?
Well, I disagree with it. It's a public road. It won't be accepted by DOT and maintained by DOT until such time as it's brought up to the standards of DOT. But at the time of dedication, it is a public road. And the assertions and the affirmative representation that the developer made is that they will make the improvements shown in this plat. But they were not required to make it public, nor were they required, or at least there's no language in there requiring them to make easements public. But I do note that there was a statute in effect at the time stating that to be the legislative intent, or there was an intent that was certainly permeated throughout the state of North Carolina to provide access to the public beaches. I don't have an express language in the ordinance that was contained here that says that it's mandatory that they do so, but nor was it mandatory that they create a public road. And I would say that this issue of whether or not someone who if there are not any other specific questions, I'm going to stop sharing this so I can get back to a screen where I can see everybody. And also see my time.
Mr. Wills, can you comment on the harm to the Hoveys and on the concept of an entire town like the town of Duck restricting public beach access?
Yeah, I believe there is in the record, the position taken by the town is that there is no public beach access within the town of Duck.
Right.
So the Hoveys, there's one parcel, it's really not in the record, so I won't go into the details of it, but the Hoveys are, and other people located on their street, Soundside, have no access to the beach. If this principle and this practice is applied, then theoretically they would have to drive 5 to 10 miles north or 5 or 6 miles south to get to a public beach access. And again, the dedications in these plats, I do believe there are other subdivisions that have similar issues. I believe, as I recite, I understand, Judge Inman, that you want me to treat the easement separate from the roads, but it's very clear that the town of Duck has the statutory authority, if they want to create parking alongside all of these dedicated roads. They have the right to build sidewalks along these dedicated roads because they have been dedicated. Likewise, but why are you going to build a parking place or a sidewalk except to benefit the lot owners unless they have access to get to the beach?
Well, the town hasn't built those, has it? The town hasn't done that, right?
It doesn't, but it's irrefutable that they have the right to do so if they make the political decision to do so at any time. And again, I kind of take the language, which I believe Mr. Shelton and the HOA argues as the developer's intent to be derived from the covenants. I do believe that these same covenants show that the HOA or the developer wants to control dedicated land in a manner that they don't have the right to do so.
Well, assuming arguendo, that's some of the covenant portions that you pointed out, like about parking, are invalid, can't work, whatever. Does that wipe out the entire document of the covenants? Does that wipe out the entire intent?
It takes back the contention that the developer's intent controls the issue of dedication. If they admittedly dedicated the road to the public without putting it on their plat, without putting the word public on their plat, okay, then the same logic would apply to their dedication of the easement without putting the word public on it. And if they had wanted to retain it, by the way, these covenants do not even establish the formation of a homeowners association. So there was no funding mechanism. There was no institutional thing that was going to care for any common property, and there was no common property at all.
And the last statement you made makes me question, is the developer's intent relevant?
Not
in your view?
In light of the language of offer and acceptance as revealed by this plat, then the outcome should be identical to what was this court held to be true in Ocean Hill. It should be identical to the easement that was given, and we haven't discussed that case, in Smith versus Durham, which involved a 3-lot subdivision and the filing of a plat showing a 60-foot easement. This court held that easement, even though the filer of the subdivision came to court and expressly said, this was never my intent. I never intended to make this public. This court held in that case that 60-foot easement was public by virtue of the plat. Also in the case of,
So you would see no distinction between that case and this one? That
No,
would be the one, you'd say
well,
that
I think it's
was
very-
closest on point to
I
this
think
one?
it's very analogous in that the intent of the owner is if you have to do this in order to get your subdivision, which in that case they had to provide a 60-foot easement in order to get their subdivision. When they later discovered, even though they didn't put on their plat, it was a public easement, that the court treated it that way. This court held, under these facts, there is, once you've accepted the benefit of your subdivision, you are bound by it.
But did the developer here have to dedicate the pedestrian easement in order to get its plat approved here?
The developer had the choice to either make it public or private. By virtue of the plat that he filed, he made it public. He could have created a private road, but he probably would have had to create then a funding mechanism to pay for its future maintenance.
So is it
He
your
elected
position,
not to do so.
and it's your position, this plat is not ambiguous? That this
That
plat
is-
is not
that is-
ambiguous at all?
That is my position, yes, Your Honor. Any more than it's ambiguous with regard to the roads. It says walks, and the plat that they reference says an 8-foot pedestrian easement. And I see that I'm out of time. If there's any other questions I can answer, I'll be glad to do so. I'm sorry, Judge Tyson, I can't hear you now, so maybe I've done
Are there
something.
any questions for counsel before we go to the rebuttal? Judge Hampson, Judge Emmon, either one?
Thank you.
Okay. All righty. Thank you, sir. Rebuttal?
Thank you, Your Honor. Several things. First, Judge Hampson, you asked Hovey's counsel whether the word or street includes pedestrian easement. And I was surprised that he said yes, because he's never made that argument before. It's also inconsistent with the ordinance. So if you turn to record page 208, the ordinance is what requires what goes into the plat. And the ordinance defines the words road and street. And it says road, a dedicated public right-of-way for vehicular traffic. The word road includes the word street. So we know from the ordinance that this plat language, streets and roads, does not include a pedestrian easement, because that's the opposite of vehicular traffic. Judge Tyson, and I believe Judge Emming, you both asked about whether didn't the ordinance require public beach access, and I appreciate opposing counsel's candor that the ordinance doesn't require that. In fact, the only thing that the ordinance requires is that if you're making a public dedication, that it be designated. So if you turn to page 213 of the record, which is the ordinance, and you look at subsection A4, it says reservations, easements, alleys, and any areas to be dedicated to public use or sites for other than residential use need to have notes stating their purpose and limitations. The surveyor clearly was reading this ordinance, and when he drew up the plat, he didn't note that it was dedicated to the public. And the town accepted it. So it seems the town and the developer all understand that this was not a public dedication. There's also the
Mr.
problem
Sheldon,
that
I'm coming back to my sort of original question at the outset, and that is there is there not a question of fact as to exactly what was offered and what was accepted based on the plat language? It seems, reviewing that, the language of offer does not necessarily match the language of acceptance, but it could. So why is there not a question of fact as to intent? Why is there not a question of fact as to offer and acceptance, or what was in fact accepted by the town?
so we can set aside acceptance. There's certainly no question of fact as to what was offered, because the offer language says, I'm going to note for you what is being dedicated to public use, and I'm going to note for you what's being dedicated to private use. And the surveyor, because of both the ordinance, which says you have to note what things are going to public dedication, and because of the background law that had already been the law for, at that point, 80 years in North Carolina, the surveyor knows I don't have to write that something's going to private use, because there's a presumption that if I don't write anything, it goes to private use and not to public use. You have to, if it doesn't say anything, and this is the key principle from Town of Wright, or Wright versus Town of Matthews, if it doesn't say anything at all, then there's a presumption that the written instrument doesn't create a public dedication. I think it's helpful for the court, if you want an additional case to look at, is the Hirsch case from the New Hampshire Supreme Court, which relied and cited Wright for that exact proposition. And in that case, there was a right-of-way, and the question was that right-of-way dedicated to the public? They said, well, the plat doesn't say, and it was a plat in that case. They said the plat doesn't say one way or the other, so the presumption applies. And if it doesn't say one way or another, then you lack clear and unmistakable evidence. And since the Hoveys were the ones that carried the burden of proof, they were the ones that had to come to the trial court to prove that this was a public dedication. And there simply isn't any evidence. If it's ambiguous, then it's not a public dedication at all. And Your Honor, you also were asking about the emergency vehicle easement. I would note that that easement is sort of speaking to the declarations that were filed just days later. If you look at page 146, which is the restrictive covenants, they say that, just so you know, we have this emergency vehicle easement. It's not for use by the public, and it's not for use by you either, the lot owners. So really the surveyor there is talking to the lot owners. And I want to go back for just a moment to the court's question, well, didn't the ordinance require the public access? But I note that under the unconstitutional conditions doctrine, if the county had tried to do that, they would still have had to pay for a taking. There was never an offer to pay for a taking. The town's never tried to use eminent domain to take this public beach access, which is what they would need to do if they wanted to take it forcibly. In conclusion, I would just like to leave the court with the standard. They needed clear and unmistakable evidence that was unequivocal, and the Hoveys didn't have any. Therefore, summary judgment should have been entered in the HOA's favor. Thank you.
Thank you. Thank you, counsel. Mr. Sheldon, Mr. Wills, we appreciate your arguments. Any further questions of Mr. Shelton from the panel?
I have none.
Okay. Okay, thank you very much. Okay, the case is submitted. We appreciate your good arguments, and we appreciate the smoothness with which everything went today, and we thank you very much. And Mr. Clerk, will you please adjourn court?
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you, Your Honor.
Thank you for good arguments.
Thank you, Your Honor.